The Supreme Court chamber fell silent. Justice Clarence Thomas leaned forward, a faint, almost rare smile breaking his usual calm face. Before him stood Representative Jasmine Crockett, a first-term Congresswoman from Texas, once a fierce civil rights lawyer. The case at hand, Williams versus Texas Election Commission. Focus on new voting rules critics said unfairly hurt certain communities. Crockett spoke clearly, explaining how past court rulings had recognized both obvious and hidden obstacles to voting. But then, something unusual happened. Justice Thomas interrupted. His deep voice filled the room. He said he found it interesting that someone so new to national politics felt confident explaining constitutional law to judges who had been studying it for decades, longer, he noted, than she had even practiced law. He reminded her she'd only recently arrived in Congress after a short term in the Texas state legislature, and implied that experience mattered when speaking on issues of this level. Several justices here, he said, have been interpreting the Constitution since before you started law school. The room froze. The Chief Justice looked surprised. Other justices shifted in their seats. Even the public gallery went still. It wasn't just a question. It was a challenge. For a moment, it seemed the comment might shake the young representative making her first ever argument before the nation's highest court. But Jasmine Crockett didn't flinch. She took a calm breath, adjusted her posture, and looked him straight in the eye. She began respectfully, acknowledging his long experience, but then said something no one expected. Without glancing at a single note, she cited one of his own written opinions from 1994, where he'd argued that federal law should protect voters only from clear, direct blocks, not wider systemic barriers. Then, she reminded him of a story from his 2007 memoir, where he described how his own grandfather had faced voting challenges, not because of written laws, but because local officials closed registration offices whenever black residents tried to sign up. Her voice stayed calm but firm. She explained that his own family story proved exactly what courts had long understood, that voting rights can be crushed not just by visible laws, but by silent barriers that feel neutral yet harm real people. What she said next shifted the entire tone of the courtroom. She connected those same experiences to the broader court rulings she had mentioned earlier, rulings that reflected the exact injustices his grandfather had endured. Sometimes, she said gently, a new perspective helps remind us of truths already written in our own histories. She ended her point by saying that the Constitution's long history doesn't make it outdated. It makes it alive, and that her short time in office didn't weaken the legal principles she presented. The law should be judged by facts, she said, not by who delivers them. The courtroom went silent again. Justice Thomas sat still, his earlier confidence replaced by quiet reflection. Moments later, the Chief Justice shifted the discussion back to the details of the case, but the entire mood had changed. Thomas's later questions were measured and focused purely on the law. The personal challenge was gone. Observers later described the moment as extraordinary. A veteran court reporter noted that Crockett had clearly studied not only the cases, but also the justice's personal writings, a rare preparation that turned what could have been an awkward exchange into a masterclass in constitutional reasoning. Jasmine Crockett's journey to this moment was remarkable. Elected to Congress in 2022 at 41 years old, she had already built years of experience defending voting rights in Texas courts. She knew how technical rules affected real people, and she spoke with a rare mix of precision and empathy. Her style had earned respect from lawmakers across party lines. Justice Clarence Thomas, on the other hand, had been on the Supreme Court since 1991, more than 30 years. Known for his deep focus on the Constitution's original meaning, he often argued for limited federal oversight in state elections. His life story, from rural Georgia to the nation's highest court, shaped his belief that legal protection should target only explicit barriers, not broad social inequalities. The case before them, Williams versus Texas Election Commission, tested those boundaries. Texas had passed new voting rules, claiming to secure elections. But critics said the rules, while neutral on paper, made it harder for many citizens to vote, especially in poorer or minority communities. Because of her legal background, Crockett was asked to help argue the case. It was rare for a sitting lawmaker to appear before the court, but her expertise made her the ideal choice. At first, the hearing followed routine patterns. Justices debated whether the rules violated constitutional standards, and Crockett explained how similar laws had been struck down in the past. She showed that even neutral policies could have discriminatory effects in practice, and that courts had long recognized this pattern. Then came Thomas's unexpected interruption, and Crockett's unforgettable reply. Her ability to stay calm, stay factual, and turn a personal remark into a teaching moment drew widespread praise. Legal analysts said she redirected an insult into insight. Law professors used the clip in advocacy classes, showing how composure and preparation can turn confrontation into clarity. When the court finally released its decision months later, subtle but meaningful changes appeared. The majority opinion, written by the Chief Justice, emphasized that judges must weigh both historical context and real-world impact when reviewing voting laws, even if those laws seem neutral. Justice Thomas issued his own opinion, still defending state authority, but with a notable acknowledgement that barriers to voting don't always appear in written statutes. For many, that small shift suggested Crockett's words had left a mark. Her appearance before the Supreme Court didn't just raise her profile. It reignited national conversations about experience, respect, and truth in leadership. Colleagues praised her for proving that real authority comes from preparation, not tenure. She showed that confidence, backed by knowledge, can command any room, even the highest one in the land. Clips of the exchange spread across social media. Viewers described her poise as inspirational. Civil groups use her example to encourage citizens to understand their rights and engage in democracy. It was more than a legal argument. It was a reminder. Calm, informed voices can reshape even the most powerful institutions.